In your packets that you received in registration, there is an evaluation form. Those of you who have been with us in prior years know that we seek to make these conferences better every year. How we can make this conference better for next year. So don't wait until the last time, the last day, tomorrow, or the last panel to fill those out. As you have thoughts as we proceed through our conference program today and tomorrow, please look at those evaluation forms and fill them out. Now, I mentioned the fact that this morning's headline in the New York Times talks about NSA surveillance. Clearly, this has been a very difficult issue, both for the Bush administration in the last 2 years and now for the Obama administration. How do we draw the balance between acquiring the surveillance, intelligence information that we need to defend the country and yet balance that against preserving individual liberties and privacy? This is a difficult issue. I think many of you know that the Congress last year passed the Foreign Intelligence Surveillance Act, Amendments Act, that tried to draw the balance. But is that the right balance? Should the 111th Congress go back and take a look at restructuring the surveillance laws in this country? That and many other issues on surveillance are going to be covered by our first panel. And now it's my pleasure to introduce the panel chair of that, my colleague at Duke Law School, Professor Chris Schroeder. Chris?
Thank you, Scott. As Scott said, our first panel is on surveillance and intelligence gathering, which is a vast and somewhat rambling topic. We can't cover it all, but we're going to try to, in the panel's opening remarks, highlight some of the most pressing issues and then leave an ample amount of time for discussion and questions from the floor if we have not paid sufficient attention to something that you're interested in discussing, in addition to follow-up questions on the topics we will cover. We have a great panel here today to discuss this topic. I'm going to introduce them in the order in which they will speak. We'll try to keep our opening remarks to about 15 minutes or so, in order to permit that active interchange that Scott referred to. First up will be William Banks. Bill currently holds the College of Law Board of Advisors Distinguished Professorship at Syracuse University. He and his co-authors literally wrote the book on national security law. It was their first edition in 1990, and now in its fourth edition, it's the leading case book for instruction in the subject throughout the country. And I suspect since 9/11, the number of law schools that are holding such courses has multiplied considerably. Bill is an accomplished scholar on a range of topics in constitutional law, emergency preparedness, executive authority, intelligence gathering, the appropriations process. He's a graduate of the University of Denver School of Law. He's been at Syracuse since 1978, has advised members of Congress and congressional committees and testified on numerous occasions, and was special counsel to the United States Senate Judiciary Committee in 1994, around the time of the confirmation of Justice Breyer. Our next speaker on the far left will be Melissa Goodman. Melissa is a staff attorney working in the ACLU's National Security Project. She's litigated cases on a wide range of topics relevant to today's panel and the conference in general, including the NSA program, the FISA process generally, the use of national security letters by the FBI and the Department of Defense, as well as litigation involving the Extraordinary Rendition Program. She's a double graduate of NYU, both as an undergraduate and the law school. And in the middle, the third speaker is Michael Davidson. Mike is currently the general counsel of the Senate Select Intelligence Committee. He's held a range of positions in the Senate, including serving as the general counsel for the joint September 11th inquiry of the combined House and Senate Intelligence Committees. He served as what was the title? Chief Counsel of the Senate or Senate Counsel?
Senate Legal Counsel.
Senate Legal Counsel in in the 90s, which was the time period in which I first met Mike. He's been a Peace Corps volunteer and worked for a number of years in the NAACP Legal Defense Fund. He is a graduate of the Chicago Law School and has, through his both his specific committee experience now and through a long association with national security and intelligence issues, a great deal of experience and expertise on these topics. So those are your panelists. In addition to myself, we'll start off with Bill.
Good morning. My job this morning is, for 15 minutes or so, to be a historian. Talk a bit about FISA from its inception in 1978 until this set of amendments less than a year ago sort of laid the table for Melissa and Mike for further discussion. The political dynamics that led to the enactment of the Foreign Intelligence Surveillance Act in 1978 were truly unique. The interbranch compromises that were reached then authorized the means for electronic surveillance of foreign intelligence that served the nation well for many years. The basic idea was really very simple. Government may conduct intrusive electronic surveillance of Americans and others lawfully in the United States without traditional probable cause to believe that they had committed a crime, if it could demonstrate to a special Article III court that it had a different kind of probable cause, reason to believe that they're acting on behalf of foreign powers. Since then, critics have argued that the basic patchwork-like architecture of FISA became too rigid, too complicated, and too unforgiving to enable effective intelligence response to crises. The computerization of communications that has so enriched our capabilities has also facilitated stealth and evasion by those seeking to avoid detection. Would-be targets of surveillance are communicating in ways that stress or evade the FISA system, and because of switching technology, collection inside the United States is now often the best, or perhaps even the only way, to acquire even foreign-to-foreign communications that were originally left unregulated by FISA. Furthermore, powerful computers and data mining techniques now permit computers to select potential surveillance targets from electronic databases of previously unimaginable size. The wholesale quality of that kind of computer collection and data mining is incompatible with the retail scope of the original FISA process. At the same time, more Americans than ever are engaged in international communications, and there's far greater intelligence interest in communications to and from Americans. Both of these circumstances increase the likelihood that the government will be intercepting communications of innocent Americans, raising as many questions about the adequacy of the FISA safeguards as they do about the adaptability of its architecture. This tension forms the basis for context for a series of post-1978 amendments to FISA, which culminated in the FISA Amendments Act of 2008. Until the 2008 amendments, FISA governed electronic surveillance of persons in the United States for the purpose of collecting foreign intelligence. FISA probable cause required that a target of surveillance had to be a foreign power or an agent of a foreign power, or since 2004, what are euphemistically referred to as a lone wolf terrorist suspect. The applications had to specify facilities where the surveillance would be directed. They had to provide so-called minimization procedures to assure that the acquisition of collected information would not be disseminated outside authorized bounds. The special court, the Article III court that meets in secret, was created to hear requests for orders to conduct surveillance. For a long time, the process worked well as a mechanism to regulate surveillance of known intelligence targets. The FISA process and its eventual orders have always been limited, however. FISA was concerned with acquisition, not with the uses government might have for what is collected. FISA also assumed that officials knew who the target is and what facilities he will use for his communications. Knowing this much enabled the government to demonstrate the required probable cause to believe that the target was an agent of a foreign power or a lone wolf, intelligence collection for the purpose of identifying targets of surveillance by collecting aggregate communications traffic and then identifying the intelligence target. In other words, FISA envisioned case-specific surveillance, not a generic surveillance operation. And the approval architecture was accordingly geared to specific, narrowly targeted applications. FISA was also based on the recognition that persons lawfully in the United States have constitutional privacy and free expression rights that stand in the way of unfettered government surveillance. Along with the revolution in digital communications, however, the idea of a geographic border has become an increasingly less viable marker for legal authorities and their limits. Using the internet, packets of data that constitute messages travel in disparate ways through networks, many of which come through or end up in the United States. These packets, along with countless Skype calls, instant messages, originate from the United States in growing numbers, and the sender may be in the United States or abroad. Nor do we think of our international communications as being in any way less private than those domestic calls. Because FISA was written to apply to the broadly defined forms of electronic surveillance acquired inside the United States, these digital technologies brought interception of previously unregulated communications inside the FISA scheme. Many civil liberties groups were beginning to complain then that the data mining that was going on more or less without regulation was leading inexorably to greater governmental intrusions into our privacy. Changing technologies have also turned the traditional sequence of FISA processes on its head. Just as we discovered after 9/11 that investigators could enter transactional data about potential terrorists and come up with a list that included at least 5 of the hijackers, a sort of reverse of the typical FISA-supported investigation, our intelligence agencies now see the potential benefits of data mining as a means of developing the potential suspects that could be targets in a traditional FISA framework. Now, as we all know, after 9/11, President Bush ordered an expanded program of electronic surveillance by the NSA. That program was first reported, of course, by the same reporters in last night's New York Times article, Eric Weisblau and Jim Risen, who reported that President Bush had secretly authorized the NSA to eavesdrop on Americans and others inside the United States to search for evidence of terrorist activity without obtaining orders from the FISA court. Although the details of what came to be called the TSP have not been made public, it's apparent through reports and statements from administration officials that the NSA had monitored the telephone and email communications of thousands of persons inside the United States, where one end of the communication was outside the U.S., and there were reasonable grounds to believe that a party to the international communication was affiliated with Al-Qaeda or a related organization. Remember that criteria. I'm not going to review the TSP or the legal arguments here. They've been well rehearsed many times over by others, and perhaps we could talk about them some during the Q&A today. To make a longer story shorter, by 2007, then Attorney General Gonzalez had decided that the TSP, which had been thought to be legally defensible outside the FISA process, could be brought within FISA, was turned over to the administration of the FISA court, and for a period of a few months was allowed to proceed with FISC or FISA court supervision. What happened a few months later is, and then by May of 2007, a different FISA court judge was unwilling to continue to manage the support of the TSP under the FISC supervision, and by that time then applications to the court were beginning to back up, and the Bush administration successfully persuaded Congress in the summer of 2007 to pass statutory authorization for the program. This initial legislation was called the Protect America Act, and it determined that the definition of electronic surveillance in FISA would not apply to surveillance of a person who was reasonably believed to be outside the United States. Now compare that definition or that criterion to the one in the TSP. No mention here about affiliation with Al-Qaeda or a related organization. touchstone for surveillance was reasonable belief that your target was outside the United States. This short-term legislation, the PAA, permitted the Director of National Intelligence and the AG to authorize collection of foreign intelligence directed at persons reasonably believed to be outside the U.S. without obtaining an order from the court, even if one party to the communication was a U.S. citizen inside the United States. So the PAA made less onerous the determination that the target is known to be abroad. And comparing the PAA to the Bush administration's program, the TSP, the main differences were that the TSP allowed surveillance of targets inside the United States, yet the predicate for collection authority under the PAA was the location of the target, not the status in relation to a foreign power or terrorist organization. The short-term legislation expired by its own terms in February of 2008 after Congress and the administration failed to agree on a set of provisions that would grant broad retroactive immunity to firms that have participated in the TSP. The FISA Amendments Act of 2008, enacted in July, conferred the immunity that had been sought by the administration and the telecoms, but it insufficiently addressed important issues that continue to stand in the way of an effective legislative scheme for foreign intelligence surveillance. In essence, the FAA, forgive the acronyms here, it's part of the environment. The FAA codified the PAA with a few additional wrinkles. The core of the new subtitle retains the broad-based authorization to collect information targeting persons reasonably believed to be located outside the United States to acquire foreign intelligence information. As with the earlier version, the FAA does not limit the government to surveillance of particular known persons reasonably believed to be outside the U.S., but instead permits so-called vacuum cleaner surveillance and data mining. In addition, the FAA targets do not have to be suspected of being an agent of a foreign power, or for that matter, do they have to be suspected of terrorism or any national security offense, so long as the collection of foreign intelligence is a significant purpose of the surveillance. Targeting might be directed at a terrorist organization, a telephone number or email address, or perhaps an entire ISP or area code. Unlike traditional FISA applications, the surveillance permitted under the FAA does not require that the government identify a particular known facility where the intercepted communications occur. On the other hand, and on a positive note, for the first time, surveillance that intentionally targets a United States citizen abroad is subject to FISA procedures, although those procedures are less demanding of the government than traditional ones conducted for surveillance conducted inside the U.S. I'll just touch on a few attributes of this program that I think are worthy of further discussion and raise some questions. First, some of the intercepted communications will be to or from American citizens. Only intentional targeting of Americans is prohibited, and the surveillance that produced those intercepts will not have first been reviewed under pre-existing FISA requirements that the target be an agent of a foreign power or a lone wolf terrorist. Even the TSP, the Bush administration program, targeted communications only where one party was outside the U.S. and there was probable cause to believe that the party is an agent or member of Al-Qaeda or an affiliated organization. The FAA eliminates any showing of individualized suspicion, even where communications of American citizens are the foreseeable consequence of the program orders. Second, the Attorney General submits procedures to the FISA court where the government will determine that acquisitions conducted under the program meet the program targeting objectives and satisfy traditional minimization procedures. After a judge approves the program, executive branch officials authorize the surveillance and issue directives compelling communications carriers to assist. Although the details of the implementation, of course, are not known, a best guess is that the government uses a broad vacuum cleaner-like first stage of collection, focusing on transactional data, where wholesale interception occurs following the development and implementation of filtering criteria. Then the NSA engages in a more particularized collection of content after analyzing mined data And the traditional FISA orders are still required for intentional acquisition of domestic communications, but the minimization rules require the government to discard communications of U.S. persons incidentally collected, but they do not require that discarding of information incidentally collected when the government is targeting someone abroad. NSA may decide to retain any communications that constitute foreign intelligence, and there's no review of the NSA decisions. The third feature that is problematic is that the legislation follows, ironically, a 30-year FISA model of focusing on targets and their location for the purpose of authorizing and conditioning surveillance and data collection. As you recall, the predicate is reasonable belief that the person is abroad. Well, all of you probably know, if you think about your communications capabilities, your personal ones, for a few moments, when modern communications capabilities are brought to bear, it's not possible reliably to tell, in many cases, where an individual is when a communication is made. From the government's perspective, the downside of relying on location of the target as a basis for conducting lawful surveillance was softened when the statutes provided that the government had only reasonably to believe that the target is abroad. But one inevitable problem with the relaxed standard is that far more warrantless surveillance of persons inside the United States will occur. Fourth, whatever one thinks of the constitutionality or policy value of the programmatic surveillance, the legislation fails to prescribe any processes for what happens next with the data that is collected through the approved program. On what bases and according to what processes and accountability mechanisms do officials determine to look more closely at individualized pieces of the traffic? Apparently, the NSA uses algorithms that purported to identify terrorist suspects out of the accumulated mass of data. How exactly could such a data-driven process sort the innocuous call to me from my Muslim friend abroad from one that's worthy of further investigation? Is the limited human follow-on surveillance then a minimal intrusion that we should all be prepared to accept if we're assured that the brief surveillance will end and a traditional FISA application would follow if further electronic surveillance is deemed worthwhile? Finally, under the new act, what can the government do with the information acquired about U.S. persons who communicate with foreign targets? Rules for dealing with this so-called incidentally collected U.S. person information were developed when our primary national security focus was overseas. The current focus on calls coming into and out of the U.S. will require some adjustments in managing the risk of acquiring communications of innocent Americans. As it now stands, the minimization, which is 30 years old, does not prevent the government from retaining information incidentally collected on Americans. Now, if I haven't numbed you entirely, or put you to sleep, perhaps at least set the table. Thank you. Thanks very much, Gil.
Thanks, Bill. Good morning, everyone. I'm going to touch on a couple of things today. First, I'm going to talk about why the ACLU believes that the FAA is unconstitutional. But I'm also going to try to touch on a couple of other big surveillance issues that I think deserve attention this year and are sort of lurking out there. And finally, I'm just going to touch very briefly on two points that are kind of near and dear to my heart, which is things we must do to improve the quality of the surveillance debate. And those are increasing meaningful public discussion of the need for and the effectiveness of a lot of these surveillance tools we'll talk about today, something that's often quite lacking in at least the public debate. And secondly, finding ways to kind of increase transparency in the debate. But first I'll follow up on Bill and talk a little bit about what's wrong with the FAA from our perspective and try not to be repetitive of Bill's very able summary. But as you've gathered, the FAA not only essentially authorized the NSA's warrantless wiretapping program, but it actually expanded the executive branch's power to engage in warrantless, suspicionless, dragnet surveillance of Americans' international communications, and in some instances, domestic communications, as we've seen splashed across the New York Times today. And they do that from inside the United States with the aid of U.S. telecom companies. And basically, so long as the government certifies that the program is targeted at unspecified people abroad, and that the government's significant programmatic purpose gather foreign intelligence, it can intentionally collect, read, analyze, disseminate information, or basically U.S. communications with people abroad. And again, just to follow up on what Bill said, I think it's important to understand that the purpose of the FAA was not limited to monitoring foreign-to-foreign communications that travel through the U.S. infrastructure, which is a valid problem. But it goes further, and it goes further to monitor who Americans are communicating with abroad, and to potentially do so en masse, because it lacks any limits on who the target may be, there's no suspicion requirement, etc. And it's really more of a kind of programmatic roving authority to gather foreign intelligence information. And the truth is that we, frankly, don't know if the government is using the FAA power to engage in that kind of mass surveillance because it's secret. Where Mike has a bit of a leg up on me today. But what I do know is that the way the law is written, it's certainly written broadly enough to authorize that kind of broad surveillance. And there's plenty of evidence that, in fact, that was the intent of the law. Part of that is the context, obviously, of the NSA program. There's evidence that that's what the government was already doing, and they wanted legislative authorization to do it. One other indicator that that was the actual intent is that during the FAA debate, the Bush administration actually vigorously fought against amendments that would prohibit bulk collection of U.S. communications during the course of FAA surveillance. And numerous officials testified that one of the key purposes of the law was to monitor entire geographic regions abroad in order to learn who was talking to Americans. So, the question of obviously targeting specific known U.S. people is prohibited under the FAA, but intentionally targeting lines, email addresses, regions, countries, with the purpose of learning about unspecified Americans and learning about who they're talking to abroad is okay under the FAA, and I think the question is simply whether that's a good idea and whether it's constitutional. And you might be shocked to learn that the ACLU does not believe that it is constitutional. But a few points that everyone actually agrees on. Well, when I say everyone, I mean us and the government lawyers in the case. That perhaps there are others who disagree. But a few things that we agree on is that we have an expectation of privacy in both our domestic and our international communications. We also agree that the FAA surveillance implicates Americans' privacy rights, even though it's targeted at people abroad, because Americans' communications will be intercepted, and intentionally so. And finally, we all agree that no matter what we feel about the warrant requirement, the law has to be reasonable under the Fourth Amendment. As I just signaled, one strong thing we disagree on is whether the warrant requirement should apply to this kind of surveillance. As Bill explained, there's no individualized prior judicial approval of surveillance under the FAA. What the FISC does is really quite limited. It reviews only the government's minimization and targeting procedures, other programmatic procedures at the outset. But every individual surveillance decision, who to surveil, what to surveil, why they're surveilling, is really left in the hands of the executive branch. And typically, a warrant is required to get the content of Americans' communications. But the question whether the warrant is required for foreign intelligence gathering is actually an open question in the Supreme Court. The Supreme Court has held that a warrant is obviously required for criminal surveillance, and in the 70s ruled that a warrant was required for domestic intelligence surveillance targeted at domestic threats, but has never answered the foreign intelligence question. We think that a lot of the reasoning for requiring a warrant in the domestic intelligence context applies with full force to foreign intelligence gathering, and we also think that 30 years of experience with FISA warrants has proved that warrants in this context are workable. But even if you accepted that there was some kind of warrant exception, the courts that have recognized such an exception, I don't think have recognized an exception that's broad enough to cover the kind of indiscriminate surveillance that the FAA allows. The courts that have found a warrant requirement have typically held that it's limited to targeting foreign agents and foreign powers, or at least those suspected of being involved in espionage or connected to terrorism. But the FAA obviously lacks those limits. For the interest of time, I won't go further into that or talk about why I don't think the FAA is justified under the special needs doctrine, but I'm happy to go into that in the Q&A. Even if we lost and there's no warrant, obviously which are basically sufficient procedural protections to rein in executive discretion and prevent abuse. And the truth is that the FAA lacks most of the, if not all of, the procedural protections that courts have looked to in holding, in finding reasonable the criminal wiretap statute and the original FISA statute, which leads one to suggest that at least some of those requirements are necessary to have a reasonable statute. As Bill explained, I think one of the key problems, and probably for me, with the exception of the back-end problems, the most troubling is the lack of any suspicion requirement whatsoever, no matter what that suspicion requirement might be or how low it is. There's no showing or finding by a judge that anyone on a particular call or email that will be intercepted is engaged in criminal activity, espionage, or even remotely connected to terrorism. And significantly, there's not even an administrative finding to that effect. As Bill explained, even the NSA warrantless wiretapping program, at least the part that was acknowledged, did require some sort of suspicion. So we've gone even further there. And suspicion is typically key to reasonableness. Lots of case law to support that. The Constitution very rarely permits suspicionless surveillance, particularly when you're talking about surveillance that's as intrusive as collecting the content of our communications. So we believe some suspicion requirement is necessary. Another problematic aspect, as Bill explained, is the lack of any, what I would call the lack of any particularity. The fact that the government does not need to identify its target, the people, or even the groups or regions it is targeting, the facilities that it's targeting, and it does not have to describe the type of communications or the conversations or emails it wants to intercept. Basically, it just has to say, we're looking for people abroad, and our significant programmatic purpose is to gather foreign intelligence information. But particularity is incredibly important in surveillance statutes. A lot of the Supreme Court case law on this point says that, and it's because they're meant to not just protect the target, but to protect innocent third parties, such as all of us who will be incidentally collected under the FAA. So particularity is particularly important. Two other important points about the lack of limits on the scope of the acquisition under the FAA. One is that the scope of the information that the government can gather is not limited to terrorism. It can be basically, it can cover foreign intelligence information, not just information about terrorism, which can be as broad as information about foreign affairs. So any information that has some foreign policy value to us. And if the purpose of the law was to help prevent terrorism, the law certainly goes broader than that. One other problematic point, which again is usually buried, but now because of the New York Times sort of front page today, is that the law actually does allow some acquisition of purely domestic communications, calls between here and New York. It prohibits the intentional acquisition of purely domestic communications. But if the government is not sure where a person is located, the uncertainty is resolved in favor of the government. If they're unsure, those communications can be collected. And I think part of the problem, and perhaps part of the problem what led to the story you saw today, is that the government basically says uncertainty as to location is the norm. That's the rule. So it's kind of unclear what's happening with domestic acquisition. But even if you accept that it's okay to have a sort of vacuum cleaner like response to acquisition, I think one of the most significant flaws of the FAA is the lack of back-end protection. What do you do with the U.S. communications you've now vacuumed up? And I don't think the FAA does enough to protect the privacy interests we have in those communications. And it's particularly important if you're going to weaken or obliterate protections on the front end that you have a strong back-end regime. For example, the FISC really doesn't give any role, to supervise on any individualized basis who the government is actually monitoring, where they're monitoring, what they're monitoring, while that monitoring is actually happening. There are some reports that they have to provide to the FISC, but that's sometimes 6 months into the surveillance. There's also no meaningful court supervision of what the government is doing with U.S. communications. Its review of the minimization procedures is programmatic. It's not individualized. So there's really no place for the FISC to monitor that. And as Bill explained, the statute really imported the original FISA's idea of minimization, but I don't think that's sufficiently protective, as I've said, when you get rid of the front-end protection that you have with traditional FISA warrants, which is individualized judicial approval of specific targets. If you were going to be more protective, I think you need things like destruction requirements. Right now, there's no requirement, as Bill said, that they destroy US communications that are intercepted, even those that lack any foreign intelligence value. And I think one thing that's worthy of debate is whether there should be a court order required for the analysis, retention, and dissemination of US communications. Even if you're not going to have a warrant on the front end, if we want them to be able to vacuum up communications, perhaps we should employ some kind of individualized judicial review on the back end. So that's all to say, we think the law needs more limits to be reasonable. I'm going to move off of FISA for a second, which I'm sure you'll all be relieved about. But I just want to touch on very briefly 3 big other surveillance issues that I think will come up this year that deserve attention. One is that Patriot Act reauthorization questions. There are actually 3 provisions of the Patriot Act that are sunsetting this year. And I won't go into those in any detail, but can in Q&A. But personally, I think it's a wonderful opportunity for Congress to make changes to the very problematic National Security Letter statute, which was expanded by the Patriot Act, but is not actually one of the provisions that is sunsetting this year. Through National Security Letters, the government can demand sensitive customer and patron records from internet service providers, financial institutions, credit reporting agencies, without prior judicial approval and without any suspicion requirement. The Patriot Act amended the law to get rid of a kind of low suspicion requirement for these letters and replaced it with a relevance standard, which was relevance to a terrorism investigation or an intelligence investigation. And in almost all cases, at least that I'm aware of, recipients of NSLs are prohibited or gagged from discussing anything about the record demand, except now there's an exception to talk to an attorney, which didn't used to be there. But I think the most troubling thing is how many of these letters are out there. From 2003 to 2006, the FBI issued nearly 200,000 national security letters, and that's about 50,000 per year. And the Department of Justice Inspector General has reported numerous abuses and violations of the law. So I think it's a good opportunity this year to both fix the unconstitutional gag provisions that the Second Circuit recently ruled that those provisions violate the First Amendment, and to change the standard. 2 other things I'll highlight very quickly that we can get into more in question and answer is the question of FBI, and more problematically, DOD and DHS monitoring lawful, peaceful protest activity. Over the past few years, there's been reports of that happening, and I think we know very, very little, particularly about what DOD is doing in that regard, and DHS as well, and I think that merits investigation. I also think a more serious debate about data mining practices is in order. We know extremely little about the government's data mining practices, where they're getting the records, what they're doing with them, and that is worthy of debate. All to say more generally that I think we need more transparency and also more debate about the effectiveness of all these surveillance tools, because we keep giving the executive branch more and more surveillance power, often to collect information in mass, without sufficient judicial oversight, often without suspicion, and often in total secrecy. But we have very little public debate about this, except for you folks in the room. And unfortunately, that debate that we have tends to be woefully uninformed, and I'll have to speak for myself, because it's very difficult to have these debates when you don't know what's actually happening. And we're really lacking debate about what tools the government actually needs and which tools are actually effective. And part of the problem, obviously, is a lack of transparency about what's happening. Obviously, that's quite difficult in this realm, but I think we can do better. We simply hear that the tools are vital, and we need to trust that. And perhaps I'm just not inclined generally to do that, but I think we need more questions. And a general conversation about whether this mass acquisition of content and records is actually an effective means of finding terrorists. There are many who believe that that kind of method is not effective for finding terrorists because it wastes resources. There's not enough information to actually come to adequate conclusions. We know it's very error prone, and it's just sort of unclear. You just kind talking about. For example, the NSA program. We actually don't know if the NSA program was effective or led to good intelligence. The only piece of information I know is unnamed source, FBI sources were quoted in the New York Times saying that the leads were useless and they were like calls to Pizza Hut. Based on that, I don't feel very confident, but I'm sure there's other information that I don't know. But it's just one example of what we don't know. NSLs, I think, are another area where I think we have to question their effectiveness or their necessity, because between 2003 and 2005, the FBI issued nearly 150,000 national security letters, but only one, according to the DOJ IG, only one led to a criminal prosecution. So I don't know how much they're needed. I also know that in every single case, there's not that many of them, 3 of them, in which the government, in which an NSL has actually been challenged in court, the FBI has dropped the demand, which leads me to question how much they really needed the information in the first place. I think I'm probably running low on time. Is that true? Okay. I'll just say one last thing then. I just, the excessive secrecy that surrounds these questions is really troubling. And I think you can see that just by the sheer number of things we don't know. For example, we've never seen the OLC memos that justify the NSA's warrantless wiretapping program. Perhaps even more disturbingly, we've never seen FISA court opinions, significant FISA court opinions that interpret the law, that interpret the meaning and scope of the FISA Amendments Act or the original FISA. And there's an entire body of secret law that's quite important and probably much more far-reaching that we've never seen. And there's lots of questions, obviously, about how the government is using the FAA and how we can learn more about that. And I'm hopeful that Congress will turn to that sometime this year. And with that, I'll turn it over to Mike.
Thanks, Melissa.
Thank you. This would have been a well-timed conference in any event, but I think due to close coordination between the organizers and the New York Times and the Southern District of New York, the conference has been guaranteed one major news story a day. Today's is one in the New York Times about a story that is described to be a story about collection by the National Security Agency and the government's response to that. And sometime in the course of today, the government will be releasing portions, or perhaps significant portions, of opinions of the Office of Legal Counsel on interrogation. Their timetable is directed at a lawsuit pending in the Southern District of New York, brought by the American Civil Liberties Union for the release of these opinions, among others. It's been a subject of great interest in the Congress, in which numbers of people, including at our Intelligence Committee, have been seeking release of at least significant portions of them. And each of these stories, given the title of the conference, which is National Security in the New Administration, poses significant challenges in the time ahead. With respect to the surveillance matter, there will be questions about, in fact, what the role of the government monitors have been. I think the Department of Justice has already indicated that in a statement last night that whatever these problems may have been did come up in the course of regular reviews which have been institutionalized both under the FISA amendments and the legislation creating a national security division at the Department of Justice. The roles of the court, because the court does have a significant role in the implementation, both, of course, of old FISA and FISA as it has been amended, and with respect to congressional oversight. And concerning the interrogation memos, I think there will be an additional challenge and opportunity for legal academia. One of the reasons that many people have been seeking the release of the legal analysis undergirding the government's interrogation program is that these matters required debate when the policies were first determined and legal approval for them was first granted. That debate never occurred. And ignorance and secrecy can easily lead to extraordinary miscalculation at great damage to the country. So what many people, including people in this room, will now have an opportunity to do is to help the country engage in that debate in an informed way as the country proceeds to make very important decisions. The President has launched a process of reviewing. He's changed the ground rules immediately, but he's also launched a process for reviewing interrogation and detention policies in the future. In our understanding of existing law, of the bearing of the Constitution on interrogation decisions, and the bearing of international agreements on them will be an indispensable part of that review, as well as for the Congress in determining whether new policies should in fact be implemented by legislation that do not depend upon changes of administration. Having some responsibility for this piece of legislation that we've been talking about mostly this morning, the FISA Amendments Act, let me talk a bit about that. As related, back in January of 2007, the administration made a decision to move the President's terrorist surveillance program completely to the FISA court. And orders were obtained from the FISA court. At the same time, there was an interest in what was called the modernization of FISA. Had this law, which was a closely debated and carefully worked out law of 1978, which grew out of the Church Committee revelations about illegal surveillance prior to 1975 and 76, when the Church Committee conducted its investigation. Should that law be brought up to date in some way, given changes in international communications and changes in the foreign intelligence needs of the United States, some of which remain constant, but others of which evolve as circumstances evolve in the world, terrorism, nuclear proliferation, of a kind not previously known. And secondly, there was a residual circumstance and impact of the President's program, which was that private American telecommunications companies who had cooperated with the government under circumstances that needed to be understood by the Congress in legislating and may at some time be more fully understood in the American public, became the defendants in multi-billion-dollar lawsuits for damages allegedly arising from their cooperation with the government. And that, it was perceived, threatened to have an enormous impact on the cooperation of American telecommunication companies with the government, a cooperation which is indispensable if one just looks at statutory law. It's indispensable in ordinary criminal law. It's been long indispensable in foreign intelligence law. We don't have a national telecommunications company. We have private companies, and their interaction with the government is key. Historically, since FISA was enacted and major amendments of the Federal Criminal Code, conducted under a system of statutory law and court supervision, a compact which was severely broken beginning in 2001. And so the question was how to repair that compact and how to deal with these many lawsuits. rejected in their entirety or significantly reshaped. In terms of collection, what the administration asked for was a major redefinition of the key phrase in any electronic surveillance law, which is the definition of what is covered, the definition of electronic surveillance. The administration sought to take out of that definition what its aim was, and an aim that did garner fairly wide support, which is that there are many communications in the world. It could be from one village in Pakistan to another village in Pakistan, and somehow it gets rooted into American electronic space, and for which there are unique opportunities to learn about a piracy plan of Somalia, a nuclear plan, somewhere else in the world, if one could take advantage of what we can do within the United States. But they sought to do it in a way which perhaps, and it was perceived by many in the Congress, to undermine some of the fundamental underpinnings of FISA concerning the protections of Americans in the United States. But while seeking to do that, the administration said, but we still want to be able to compel those providers, American companies, to cooperate with the government. We'll have less court supervision, but we'll have a greater power to compel protection. Now, these providers might have their own rights to seek relief in their own name, but it would not have been in the implementation of a court-approved scheme. And then for the damage suits against the companies, the administration sought something broader, which was relief for any person involved in the program, and that could have very easily included government officials who had responsibility for the program. The rejection was of the idea that there would be no court supervision of the entirety of the program, the great envelope of the program. And the rejection of the idea that in any way there should be a change in any of the language that governed the interception of the communications of Americans here in the United States. So fundamental to the congressional response was that electronic surveillance would not be redefined in the statute, in what became the permanent statute. Permanent, I say it's only permanent, until the end of 2012, because a key aspect of this is a sunset and an opportunity to re-examine this within the next number of years. And the rejection on the immunity side was the rejection of blanket immunity for anyone involved in this program, and one that was targeted to the cooperation of the electronic communication service providers with it. Let me describe a couple of elements of this statutory scheme. Because the perception is, and the conclusion in the Congress, and one that I think is very widely shared within it, that it is important for the government to be able to use the opportunities in the American electronic communication space to learn about events outside of the United States, and to do so beyond terrorism. Now, obviously, terrorism is a heightened concern of everyone, but nuclear proliferation is as well. Whether North Korea had a satellite on top of that missile or did not have a satellite on top of that missile, whether India and Pakistan are moving closer to war, which could be nuclear war, whether there are machinations in the international financial system that may have severe consequences to the United States, and negotiators on behalf of the United States should have knowledge of that as they seek to enter into agreements with other nations, cooperatively or defensively, in relation to other nations. trouble to us definitely include terrorism, but terrorism is not the exclusive list of those things. So that was a first decision. Should this be a system that embraces the span of potential threats to the country? Secondly, if greater leeway is to be provided for the collection of foreign intelligence in which the targets are outside of the United States, what kind of system should we have in order to assure that, in fact, there is a high degree of accuracy in the assessment that those targets really are? And my colleagues are correct to point out that is an increasingly difficult thing. Our email addresses are ones that we could use in different parts of the world. Our cell phones are things that we carry around, both within the United States and outside the United States. And so there are enormous technical challenges and systems engineering requirements in order to make that judgment. The prior administration would have left that entirely to themselves to make that. But a fundamental decision in the FISA amendments was that although individual targeting decisions, whether it's a criminal wiretap or an intelligence incidental communications will be acquired. Someone will be calling that person who was not the target of the communication. It could very well be that the person who communicates, in fact, is in league with the target, that there's a vital interest in that person's communications, but it could be a member of that person's family who is communicating about something entirely different than whatever may have been the intelligence interest that attracted people to that particular email or that particular phone number. And we have built into our U.S. intelligence law, as well as our criminal law, the concept of minimization. There are sets of rules which govern the acquisition, the retention, and the dissemination, and increasingly strict rules that are designed to protect the privacy of Americans. The previous administration's proposal was that those rules themselves would be entirely the province of the executive. And the Congress, in fact, had accepted that in the interim measure, the Protect America Act. But the FISA Amendments Act made that, too, a matter that requires court review. The FISA Amendments Act requires that the court, in reviewing the government's documentation, not only look at statutory compliance, but determine whether the statutory compliance adheres to the Fourth Amendment, the reasonableness part of the Fourth Amendment. Now, maybe the court would have been required to do that anyway, but that's an explicit statutory matter. And then, very important to the final compromise with the House, the government had wanted whatever that court review to be one that followed the commencement of acquisition. And what the Congress ultimately insisted on is that the ordinary timing would be one in which the court review of those systems, targeting, minimization, adherence to the Constitution, would precede collection unless there were emergent needs, in which case they would have to follow immediately. And then to pick up on something Bill mentioned, the Congress took a further step, which is to do something that had never been done before, and that is to provide statutory protection for Americans who are abroad. It became an interesting fact in the development of the legislative history of this measure that there are something like 4 million Americans who at any time are outside of the United States. And that's as many Americans who were in the United States at the time of the framing of the First Amendment. That is, we have an equivalent population that's somewhere else in the world. And once members looked at that, they were absolutely puzzled. Maybe everyone should know, but they were absolutely puzzled that, in fact, the law had made a distinction between the rights of Americans outside of the United States and those who are inside the United States. And so, in two ways, the Act requires, one, if the collection is from within the United States, the full set of FISA provisions apply. The application looks to be just exactly the same as if the American was in the United States. And then, and this was a much more difficult one for the administration to accept, but it did accept. What about when the collection is outside the United States? When the United States is working surreptitiously or together with friends in the world to conduct not only electronic surveillance, but physical searches or any other kind of intrusive search that within the United States would have required a warrant. Now, for the first time, there is at least the requirement that the government submit to the FISA court its justification for determining that those people are agents of a foreign power or a principal, or in this case, an employee of a foreign power. And that the court determined that there's probable cause that a person fits within the eligible category. And that's a significant advancement in the statutory and constitutional rights of Americans abroad. So, this is an act, and there are multiple views about this act, but this is an act which wrestled with and made very fundamental decisions about the role of a court, not individual warrants, for the approval of the system, but individual applications in connection with any circumstance, either under old FISA, Americans here, or under these amendments, Americans traveling overseas. But the proof is then always in the implementation, and that's the challenge to the new administration. The National Security Division is headed by David now, who was a significant pioneer in legal academia and national security issues. The vote approving him in the Senate was 96 to nothing. There was a desire for a roll call vote, and everyone who was there at the time approved him with wide support. He's got a big challenge. And the challenge is, as in any statute, but particularly this one, in which there is very little visibility about the operations of the statute, is how does the government internalize the controls? How does it establish the internal rules that carry the statute out, that are sensitive to the balances that need to be created? And I'll wind up with just this. This isn't a eternal self-perpetuating system. There's the sunset at the end of 4 years. Also, these authorities may last no longer than a year without another interval of court review. So this act was enacted in July. When consumed in close proximity to July, there will be another set of annual submissions. The government will have to explain its implementation. There have been a set of Inspector General requirements for reviews so that the court and the government will have more information, and they'll have to make their case to the court with a considerable amount of congressional oversight. Last thing, also in July, is the due date for an Inspector General review of the President's terrorist surveillance program. The Congress provided for immunity, focused on the carriers, not for government officials. But in light of the fact that the litigation that had been underway against the carriers would be terminated by the immunity provision. There's a challenge to the constitutionality of that is pending, but if it's upheld. And the litigation would not be a vehicle for public accountability. The determination in the Congress, this is a Senator Leahy amendment, would be that there be a comprehensive Inspector General review. Inspector Generals, in the end, will have a report, which is to be unclassified, but may include classified matters. High on the list of challenges for the new administration is going to be what is the balance in that report between the public side of it and the classified side. It's not an easy one because, and this is a point of view, in contrast to interrogation, in which I believe, again, a point of view, that we have seen the end of that history of coercive interrogations. The surveillance part of the world is a different part of the world because those techniques, under a different regimen, but those techniques are techniques that one continues to use in one form or another. And the ability to describe those publicly so that there is accountability, but still in a way that allows for the utility of them is going to be very significant.
Thanks very much, Mike. I'm going to take just a few minutes now to really extend in one direction Melissa's closing remarks about the need for accountability and transparency, and then also Mike's reference at the end to the litigation that's been going on with respect to the terrorist surveillance program. And just to telegraph the punchline, notwithstanding the ACLU's success on the interrogation front, and again to repeat and then amplify what Mike said, the courts are not going to be, in my opinion, a very helpful source of information with respect to surveillance activities. So we're going to have to look for other venues. It's going to be executive branch self-disclosure, it's going to be the Inspector General's report, it's going to be something like a church committee, possibly. But there are limitations in this area to what the courts are going to be able to do, and I just want to bring the audience up to date on the efforts, the sometimes heroic efforts that have been made to try to pry open the black box of the president's program prior to, the way it existed prior to the New York Times story in late December of 2005. So some people are eager to put blinders on with respect to this question and to say, well, that's a program that existed then. Let's not go into it. We need to worry about the methods and procedures and the rules and operating instructions going forward. At the same time, others think we do need a reckoning about the extent of the surveillance that occurred and a reckoning with respect to its legality at the time. I don't want to talk about the merits of those legal issues, but I do want to spend time discussing some of the obstacles that the plaintiffs have faced because they will persist, I think, in this area for some time. I think it's one of the vital aspects of our system of government that people can demand access to information that the government doesn't want to release, and the government doesn't have any control over those demands being made. So it's interesting, though, that once you get into the litigation, the government appears to have a great deal of control about whether those demands actually result in any information being released. But once the Bush administration's warrantless surveillance program was known, a number of lawsuits were filed, both against the government itself and against the service providers, the cooperating telecoms. Eventually, some 40-odd suits were consolidated in a multi-district litigation proceeding in the Northern District of California before Judge Vaughn Walker. Now, during the Bush administration, Justice Department lawyers insisted the district court should dismiss each and every one of these suits, and they raised a phalanx of threshold legal hurdles that they argue stand between the plaintiff and getting to the merits, getting to any substantive information about the surveillance program, and that none of the cases could survive them. One claim interposed by the government is that the plaintiffs can only sue if they could prove that their conversations were among those that had in fact been intercepted by the NSA. And since the program is secret, and since the government is not admitting that any particular individual or conversation has been intercepted, they lack, in the constitutional parlance, the plaintiffs all lack standing to sue. Several cases have been dismissed on roughly those grounds, on standing grounds. If you got by standing, a second obstacle that the government has raised has been the state secrets privilege. The Supreme Court has long recognized a privilege that protects military and national security information from being disclosed in a lawsuit in court when the official in charge of maintaining this classified information officially raises the objection. The powerful feature of the state secrets privilege is that when it operates, its effect is absolute. There's no balancing of the need of the plaintiff versus the nature of the harm that would be done to the country if the information is disclosed. It's a privilege that is absolute and can result in the dismissal of the case. If the inability of the plaintiff to get access to the now state secrets protected information makes it impossible for him or her to make out a prima facie case, the case can be dismissed at that stage, or assuming you could prolong it longer, if it resulted in a failure of being able to prove by a preponderance of the evidence, the plaintiff would lose on those grounds. So those are two formidable obstacles. No case filed against the government itself or against the service providers since 2005 has yet come close to getting to the merits of the issues either of legality or the substance of the content of the program. Questions like how it was operated, what the decision rules were, how many telephone calls were being, or other forms of communication were being intercepted, who decided who was targeted, what kind of internal review there was, or about whether the acquired communications were obtained and stored, what the minimization rules were. All of that remains classified information. Now these obstacles standing in the way of litigation did not satisfy Congress. As Mike indicated, Congress decided there needed to be a third one. So they enacted in the FISA amendments of 2008 a retroactive immunity provision to respond to the telecom companies' anxiety over their potential exposure in the case, and also building on the historical precedent out of a worry that if the service providers were found to be liable, this would send an awful message going forward for the next time the administration was seeking the cooperation of service providers who are essential in many surveillance activities, and would be met instead of by a sense by the CEO that if the president is asking you the urgent needs of national security, that you ought to be cooperating with the country. Instead, they would be shuttled down to the general counsel's office to engage in a heated debate over the legality of the surveillance. The argument that telecoms made was if the president came to us with an assurance that the program was vital and it was legal, we ought to be able to respond by cooperating, not by resisting. And that argument, after a very heated debate, eventually prevailed. So there's a provision in the 2008 amendments that says that authorizes the Attorney General to submit an affidavit certifying to two facts in any litigation. One is that the service providers were assisting a surveillance program that existed between September 11th, 2001 and January 17th, 2007. And second, that the provider had been given written assurances that the program was authorized by the president and determined to be lawful. And thereupon, if a judge found that those assertions were supported by substantial evidence, the judge is to recognize the immunity and dismiss the case. So Attorney General Mukasey has made these certifications in all the telecom cases in San Francisco. The plaintiffs have raised a number of legal challenges to them, constitutional challenges. They've been briefed and argued. We're awaiting a decision by Judge Walker on them. I'm not holding my breath. I don't think that these challenges will succeed, but we'll see. I'm not Judge Walker. But as I say, even absent retroactive immunity, you have these formidable obstacles to litigation standing in the way of litigation. So it's hard for me to see how any of the cases before Judge Walker are going to get past all three of these
obstacles. It's like the wedge in football on a kickoff of a very beefy lineman coming down the field, and you might cut one or the other out, but it's hard to see how you're going to get past all three to tackle the runner. Except perhaps the one special case. It's a case that once again proves that reality can be stranger than fiction. It started back in 2004 when the Office of Foreign Asset Control of the United States Treasury froze the assets of an Islamic foundation, the Al Haramain Foundation, preparatory as a preliminary step to having proceedings to declare the foundation a specially designated global terrorist. In the course of challenging the designation, Al Haramain's lawyers requested in discovery certain documents relative to the determination. A large number of unclassified documents were turned over to them, and somehow shuffled into that stack of unclassified material was one that was stamped as top secret. They had been inadvertently given a highly classified document. The Al Haramain lawyers copied the document, showed it to the foundation's board of directors and to at least one reporter. 2 months after the inadvertent disclosure, the FBI retrieved the document and all the copies that the attorneys had, although apparently they did not attempt to retrieve all the copies that were in the hands of the board of directors or otherwise had been distributed. 2 months after these events, with respect to the document, the New York Times story of 2005 broke, and Al Haramain's attorneys did their own connecting of the dots. And they concluded that the document proved that the foundation and its Washington-based attorneys had been subjected to surveillance under the TSP. They then filed a suit against the United States alleging violations of the FISA and of constitutional rights, and they provided a copy of the sealed document to the court. The United States sought to prevent its use, invoking state secrets, saying that the inadvertent disclosure did not vitiate the privilege, and also saying that the document could not be described, the contents of the document could not be described in any meaningful way without revealing sources and methods of intelligence. The district court agreed with that characterization, but it also concluded that it would be possible for the attorneys of Al Haramain to file an in-camera affidavit on their own signature, a known knowledge, attesting to the contents of the sealed document. And on that basis, they could establish standing and use that information in proving their prima facie case. The United States appealed. The Ninth Circuit agreed that with the district court that the state secrets privilege covered the document, but it disagreed with the somewhat Solomonic solution that the district court had tried to effect, and saying that if you allowed the attorneys to testify in an affidavit to the contents of the sealed document, you would be countenancing a backdoor around the privilege that would eviscerate the privilege itself. Remarkably, as the Ninth Circuit was closing that backdoor, it was opening one of its own. The Al Haramain attorneys had argued in the court below that when you're dealing with information with respect to surveillance, state secrets, the handling of privileged information through the state secrets privilege is superseded by the statutory procedures in the FISA statute instructing how district courts are supposed to handle FISA-relevant information. In the normal context in which this would arise, it would be a case in which the United States had decided to prosecute someone on the basis partially of information obtained through a FISA warrant, and the statute requires that fact be disclosed to the court. And then there are procedures for the defendant to raise objections, at which point the judge can invoke a procedure that allows him or her to receive in camera the classified information and to evaluate it. Also a procedure to let the plaintiff's attorney or the defendant's attorneys in the criminal context have access to that information if the judge believes that having that adversary proceeding is necessary in order for the judge to be able to determine the authenticity of the FISA information. And the Department of Justice reports that in the 30-odd years of FISA, a judge has never taken that step. Always the in-camera procedure has proven to be enough to satisfy the judge of the validity of the original order and documentation that the Justice Department submitted to the FISA court to get the
intercept order in the first place. Case goes back down to the district court. Now it's before a different judge. It's before Judge Walker. This case started in Oregon before the MDL procedures had been established, and while it was on appeal, it got reassigned to Walker. So it goes back down to the Northern District of San Francisco, and the Judge Walker now is in the very interesting situation, up until recently, of being the only person in the courtroom arguing about the case who's not seen the sealed document. He, however, issues a series of rulings over the past 9 months, all of them in the plaintiff's favor. First, he ruled that FISA does supersede the state secrets privilege, so the FISA process would apply to his handling of the document. Then he ruled the plaintiff had satisfied him that they were, quote, aggrieved persons, close quote, which is the only class of people who can invoke these FISA procedures under the statute. And then in January, he ruled that the government had to make the sealed document available for his in-camera inspection, which hasn't taken place, so now the judge knows what's in the document. And he also ruled in January that the United States had to provide expedited security clearances for the plaintiff's attorneys so that they could be available to participate in further proceedings that may now have to occur in camera because of the classified nature of the information, if he determines the case should go forward, as it would appear that he is about to determine on the basis of the sealed document. So the government's been resisting each and every step of the way. It continues to argue state secrets governs and FISA does not. It sought a certification on that question from Judge Walker to be able to appeal it immediately to the Ninth Circuit. He refused. It filed its own collateral order appeal without the certification, which the Supreme Court denied. And while it has processed security clearances for the plaintiff's lawyers, as you know, being cleared is only one condition to be satisfied before you gain access to classified information. The second condition is that you have to have a need to know. And on that issue, the government is insisting that the executive branch is the exclusive determiner of whether there is a need to know and not the court, and you can imagine what their answer to that question will be. Now, it's worth remarking, come to the close of this little saga, that in this quick review of the sealed document case, I've been referring throughout to the government's litigating position without any regard to whether the lawyers have been representing the Bush administration or the Obama administration. And that's because there's absolutely no distinction I can see to be drawn between the litigating position in this case before and after January 20 of this year. There doesn't appear to be a dime's worth of difference between any arguments that the Obama attorneys, who by the way are the same people, the career lawyers in the Department of Justice don't shuffle around the changes of the administration before and after January 20. Now this has left a number of people puzzled who were expecting something of a sea change in cases like when issues, particularly state secrets issues, have been raised. And we could spend some time speculating about why there's more continuity than difference. But I don't want to go there now. I simply want to conclude by saying, well, suppose the government continues to lose these arguments and Judge Walker continues to proceed to craft a way under the statute to litigate this case. It's highly unlikely even then we would gain any information out of this case about the nature of the TSP because the proceedings are classified. They are proceeding in camera. Press is being denied. I don't see how the judge could write an opinion. He may not be able to issue an order, a public order, announcing a verdict in favor of the plaintiff for fear, based on government arguments that would have to be made, that acknowledging the existence of this particular surveillance would in fact reveal sources and methods that are still relevant to the ongoing operations of this kind of surveillance under the amended statute. So there's an eye of the needle quality that has to be threaded to get a piece of litigation past these threshold hurdles in this area that very few cases can satisfy. We have this one concatenation of curious events that leads you to think that maybe the sealed document case could go to the merits, but it would, even then I think it will not become the font of information about the nature of the program, which is only to ratify the importance of the Inspector General report that we're about to see later this year, and a good deal of, I think, continuing congressional oversight about this matter. So with that, I'll conclude, and I think we'll, unless any of my colleagues feel the need to,
Let's hear from
yep, let's hear what you have to say on these topics or any others related to the general topic. Yeah, this gentleman here and one over here.
Over here?
To both places, two gentlemen, one sitting there, over here.
Thanks very much. I'm Edward Alden from the Council on Foreign Relations. I have a question that takes off from the last point that Melissa made about the need for this sort of surveillance. There was a lot of talk here about the legal framework and about where you draw the lines. But is there a consensus on the panel that the events of 9/11 combined with the changing nature of information technologies justify a far more expansive sort of surveillance authority than was in place during the Cold War, for instance, when obviously the threats to our security were rather great. Now, obviously, I'm not trying to claim there wasn't expansive surveillance during the Cold War. There was, but a lot of that was uncovered later. It was considered to be abusive. That was why the whole FISA framework was put in place in the first place. I'd just like to hear from the panelists, is there a consensus that yes, in fact, we do need a much broader legal authority than was in place before 9/11 because the threats and or the technologies have changed to a point where that is deemed necessary?
So the question includes an assumption, part of the question, whether this is a more expansive approach to surveillance. The government has argued that, in fact, if you look at worldwide surveillance, the ability that had never been affected by the Foreign Intelligence Surveillance Act to conduct surveillance around the world, to use satellites to intercept matters before they arrive in the United States, has been used for the full range of what are understood to be threats against the United States. That this doesn't add to the span of that collection, which changes over time as foreign policy needs or threats are determined, but provides an opportunity for an additional, perhaps sometimes redundant, but redundancy is a value because one technology in one part of the world may pick up 75% of something and one wants the other 25%. Communications are broken up as they travel around the world. One wants to get them all and not miss any parts of them. So that this is not by itself an enlargement of the list of things that are of concern to the government. That may be happening separately as international circumstances evolve. So people may not have been interested in piracy in Somalia because that simply wasn't a problem. So I think it's what I said at the beginning of that, more than anything else, which is a supplemental way of acquiring information about things that are separately determined to be of foreign intelligence value.
I'll just add that I think one other perspective on the same points is to remember a metaphor I used in my remarks. I think there's been a change from a retail to a wholesale collection. So as I think I said, it's turned the process on its head. That's not to say that it's good or bad or that it was lawful or not. It simply inverts the focus. Suck it all up. It might be the same as it's been for decades, but because of digitization and capability of computers, speed, stealth, invasion, it's much easier, more efficient, and maybe much more effective for the government to be able to do wholesale and then look for the needles in the haystack.
I guess I would just add briefly that if in this language of wholesale, I don't think the ACLU's position would be that turning to that kind of wholesale method targeting those communications. Whether the answer then was to go into a sort of dragnet style system, I think we just don't know enough to know whether that was necessary or not. I frankly don't. There have obviously been changes in technology, but there's also been increasingly important privacy interests that are at stake with respect to international communications, be they personal, business, things like that. And the calibration might not necessarily be to accept the wholesale collection. I also believe that we never really saw any information. Understandably, there are changes in technology, but I don't feel as if we've seen enough information to show that the original FISA system was either not working or was too costly to target those people abroad. That would justify, for me personally, this is my personal opinion, moving over into a kind of wholesale model. Perhaps if there was more public evidence of that, I would be satisfied, but the only piece of information I have is that, between 1978 and 2007, there were, over 20,000 FISA applications. The FISA court denied 9 of them. I think my statistics are up to date, and I haven't really seen any details about why that wasn't working and who we were missing or how much it was costing to do those applications. So I don't think necessarily we would agree with that assumption.
Let me just add one other thing, and this comes from the public filings in the case in the Northern District of California on the implementation of the immunity title of the FISA amendments. One basis for the Attorney General's certification is that the particular assistance alleged had not been provided. Others were that they were provided pursuant to either orders or the President's determinations under the terrorist surveillance program. But one was not provided. And on the face of public pleadings, the government has specifically denied the allegations and the complaints pending out there that there was vacuum cleaner collection. Now the substantiation for that is all in a classified file. Before we leave this, I mean, should be aware that it's the government's view, notwithstanding the public discourse about vacuum cleaners, that's not what the government was undertaking.
Can I just clarify one point about that? It's my understanding that, and you're right, obviously, that this is a more recent case filing, a totally different case. But this is about the old program, not what's happening now under the FAA. And what they did deny is that there was a massive content dragnet. However, the government has continued to refuse to confirm or deny whether there was vacuum cleaner-like collection of call record data. And obviously there are differences between the content and the call record data, but I think we all know how much these days can be pieced together about our kind of movements, purchases, dealings when it comes to call records. But that was about content. But it doesn't necessarily touch on what's happening now under the FAA with respect to content.
Sure. Thanks. Nathan Sales from George Mason Law School. Let me ask my question and then describe the problem that I think gives rise to the question. So the question is this: to what extent does the panel think that back-end limitations on what the government may do with information that it collects can be adequate substitutes for the sort of front-end restrictions on collecting information in the first place? Now, here's the problem that I see. FISA is a very good tool for collecting information about known threats. It's not so good at collecting information that you use to determine who's a threat in the first place, right? If the threat is the KGB station chief in Washington, we already know his identity. It's very easy to establish predication to justify collection on him. With asymmetric warfare, with asymmetric conflicts, however, the identity of the target is the problem. That's precisely the problem that we're trying to solve. So FISA assumes information about the identity of a target that may not be a justified assumption in the case of unknown threats. So one solution might be simply collect all the information, the vacuum cleaner, the wholesale approach, whatever metaphor you want to use to describe it. So eliminate or weaken restrictions on the front end, on the collection side, and then impose limitations on the back end of what the government may do with it. For instance, we've heard the possibility of some sort of ex post judicial review that would be in place before information that might be flagged by a computer system that's relevant could be seen by human eyes, or there might be some sort of administrative process on the back end. Those sorts of processes are under-theorized in the literature and under-discussed in Congress. So I'd be interested for the panel members to give their views on to what extent, if at all, those sort of back-end processes can substitute for front-end collection limits.
I'm coming around to think that there may be some real value in working hard at just that end of things in the legislative process this year. For years I've argued against that in my own writing. I wrote something a couple of years ago called The Death of FISA, and I meant it, I think for the reasons that you just mentioned. There's another problem though, I'm torn actually about this. The problem is that looking at the front end, as I indicated, and I think both my colleagues here agreed in their presentations, using location as a predicate is incoherent. You know, I'm Bill Banks, and here I am in the last couple of months. I've been in Bahrain, I've been in Dubai, I've been in Israel, and I've been in Omaha. How would you know where I was at any given moment? And who cares? That's the side. David Chris has pointed out in his own work on modernization for the last few years that using location as a predictor is logically incoherent. We can't do it very well. So the legal problem was solved in the short run by lessening the predicate reasonably believed to be wrong. But it's not very effective, it seems to me. If you can't do better at the front end in some kind of way that will satisfy the government and those who are concerned about privacy, then I agree with you that there may be some value at looking at the back end. It was important, I think, that, as Mike pointed out, that between the short-term legislation in 2007 and the amendments last year, a lot of work was done to re-engage the court and to insist on some congressional role in monitoring and accountability. And this year, because of the sunsets, there will be FISA legislation because 3 important provisions will expire at the end of this year if they're not. So as part of that legislation, I'd support some careful work at substituting back-end controls for the incoherence of the front-end system.
Just very briefly, I mean, I'll give you our litigation position first, and then just kind of talk on my own. You know, our litigation position is that the front-end aspect of this, whether it violates the warrant requirement or simply renders the statute too broad and unreasonable, is problematic. And the example, you know, you provided, you know, just to be clear, the original FISA didn't, I think this is right, didn't require that the actual naming of particular people. It just specified that, you know, we think someone on this particular line is problematic. So they didn't actually have to know anyone's name. But I think the thing that I wrestle with is if, I do think we need better front-end protection. And I think the key to that is some kind of suspicion requirement and how it works out. I mean, all I know about the acknowledged NSA program is that that program actually required a suspicion determination. Do I prefer that determination to be made by a judge? Absolutely. Do I prefer it to be made by an administrative official rather than not at all? Absolutely. I'm not quite sure why we can't have an effective system that at least requires some either showing or even an administrative determination that says, I'm not just going to vacuum up all calls between the US, New York, and anywhere in Afghanistan. I'm going to target, you know, those areas where I think there are terrorist activity, or et cetera, whether it can be narrowed on that front. And I think the law requires it to be much tighter, both with respect to acquisition and judicial involvement on the front end. However, with that said, on the back end, I really do think there's a lot that could be done. I mentioned before this idea of court orders to kind of further in the analysis process, even just structure requirements. I would just point out, and I think this is accurate, that in original FISA, there's actually a whole portion of surveillance we never talk about, which was the warrantless surveillance of embassies. And the idea was you could do that sort of like you could do FAA surveillance. You could surveil embassies under an attorney general authorization for a year, but there were strict requirements because the idea was you don't think there's going to be U.S. persons involved in those communications. But when they were, FISA, original FISA, actually has strong requirements that say if you get a U.S. communication, you have to destroy it. And I think that's even true for foreign intelligence values, I'm not sure. And I believe there was a provision that suggested this kind of court order necessary to share it or do anything with it. So I didn't entirely just make it up. And I think it's worthy of debate. But until I know more about technological capabilities, which I might never know, or understand why the vacuum was necessary rather than some limits, I will continue to advocate for better limits on the front.
It's a question that gets you thinking about what interest is being protected with these rules, because privacy is a multivalent concept. Much of what got people outraged in the Church Committee reports were instances in which retained information had been misused in some way or another. So a kind of thought experiment would be, suppose we had a system that just swept everything up, but was really good at screening out the extraneous stuff so that all that came through the filter, maybe it's all done by computer at step one. So the algorithms are really very highly refined. Everybody's calls are being swept up. A computer is processing them and spitting out only the ones that we have reliable ex post analysis to conclude have something to do with terrorism or related national security topics with some margin of error, but very high probabilities. Is that an offensive program or not? Well, it looks a lot different than a program that's sweeping information up and you have no idea how good the algorithms are and you have no idea how long the information is being retained. There's something too, I think, the value of simply knowing that your stuff is not being overheard unless some government official has some good reason to overhear it. But those are two very different kinds of programs. And we don't know, but I think all the reporting that we have is that the algorithms we have so far are not don't nearly meet the thought experiment in the beginning.
Scott Silverman, Bill, both you and Melissa have been critical of last year's legislation. There will be legislation in the 111th Congress. My question is, with the advances of technology, is it prudent to think about going back and scrapping FISA entirely and starting anew, or continuing the Band-Aid approach of continuing to amend? What should the Congress do?
I'd scrap it, and I'd start over. I think the foundation won't support the building any longer. It's difficult for me to say that because I've been a student of this for a long time, and I do think that the mechanism worked remarkably well for a long time. But now, the incoherence of location, there's another fundamental problem with the traditional structure. The idea of suspicion based on foreign agency itself fell apart when the lone wolf provision was added a few years ago. The Moussaoui case is the poster child for the development of lone wolf, even though he turned out not to be the guy they originally thought he was. Lone wolf, of course, allowing you to go surveil anyone who's suspected of being involved in terrorist activity decimates the idea that what you're searching for is connection between target and a foreign power, an international terrorist organization. So both those two key ingredients of the basic architecture simply aren't workable anymore. They're logically incoherent. So I go back to the beginning if it's possible. It's a tremendous amount of work on the Hill to start over into a scheme that replaces those incidents of the basic structure and still does a good job with program, front end, and back end.
Well, the subtext of the sunset debate in Congress among congressional staff was, what sunset would guarantee that we weren't around next time?
What's the answer?
Well, it's not this year. And I genuinely think that we need to have some period of experience under the system that's been created by the FISA amendments. And it's an experience which is coupled by new management. Is what will the National Security Division, which has got to conceptualize this and implement it for the Department of Justice, do in the shaping of the effectuation of this scheme? And what will it learn from that? And that this year and next year is too soon for that. In addition to the economy, it ought to come at a time when there's both knowledge and ability to focus. Now, one never knows what the competing legislative demand will be. But on the question of what the right time is, one of the serious questions to consider in relation to the several matters that are set for sunset at the end of this year is the anomaly, which is different than the original Patriot Act, in which all the sunsets occurred at one time, and then several were continued on to a time. Now we've got parts of FISA sunsetting at the end of this year, and the FISA amendment sunsetting at the end of 2012, when perhaps the need is to look at FISA in an integrated way rather than plucking out parts of it, because it is intended to function as a body, and determine what the right year is, whether it's 2011 or 2012, to look comprehensively at it rather than go through a series of sunset periods.
This time is winding down. I guess I'll pick up on that point. I think instinctually, and I'm speaking for myself here because I don't work with our legislative office. I don't want to get myself in trouble by finding them technically. But I think instinctually, I actually sort of agree on sort of this comprehensive review idea. And part of that is not just about the FISA Amendments Act and whether we should scrap that architecture that I've kind of already said. I still wasn't convinced that we needed to scrap original FISA in the first place entirely. But this question of how all the authorities work together, how national security, information gleaned through national security letters, how does that feed the FISA process, or how does that feed into the FAA process? What about all these data mining activities that we actually know absolutely nothing about? How does that feed into that system? And if there was going to be some kind of intelligent, comprehensive review, that could be nominally public in some way. I might, personally be supportive of that kind of approach. But again, I think we're hampered by the fact that we still just don't know. I agree. In some respects, it's better to see what's happening. Privacy litigator in me says, well, that's a number of, many more years where I think our privacy rights are being impeded under that system. But
integrating national security and surveillance authority, a great topic for the panel for next year. Will you join me in thanking this year's panel?
Thank you, Chris. We will now take a 15-minute break, and the next panel will start at 10:45.